lecture concerns the location of the regional human rights system within international human rights law. Now, if we talk about human rights, the primary location where human rights needs to be realized is at the national level, at the state level. We've seen the rise of constitutions protecting human rights over the 20th century, more and more states having bills of rights, for example, in place. But simultaneously, we've also seen the rise of international human rights law. And international human rights law, really, we can see exists at three layers. So if the nation state is here at the core, the first outer layer would be the sub-regional level. That, for example, in Africa would be the Economic Community of West African States or the East African Community. The next layer outside that would be the regional, the continental level of human rights protection. And the outer layer would be the global, the universal layer of human rights protection under the United Nations. And it is at that level where it started in 1948 with, as we know, the Universal Declaration being adopted. Over time, more and more, there was a humanization of international law. The human being was seen to be a subject of international law, not only states. We've seen the adoption of treaties that protect various aspects of human rights. Now, let us then first ask ourselves, what is the rationale? Why should we have these outer layers, these international layers of human rights protection, when the state is supposed to be the primary entity responsible for human rights? I think there are three reasons for me. The international serves, if you like, as a gravitational force. It serves as a pull towards which all states in the world gravitate. There's a minimum core of human dignity that all states in the world should observe. And that is the role of international human rights law, to draw all states towards that consensus. The second is that the international provides a form of independent scrutiny or supervision of what happens in the state. Even the most well-intentioned states will falter in respect of human rights. And the international then provides a form of scrutiny and correction. And thirdly, the form of correction is often that there is some kind of a safety net that international law provides through complaints mechanisms, for example. Now, it still maintains that the state is the primary rights protector within the system. But the state's role is complementary and subsidiary to the international community's role. So the international community only comes in, the international human rights protection system only comes in once the state fails. For that reason, for example, we have the principle of exhaustion of local remedies. The individual first has to ensure that the state is given an opportunity to redress violations of human rights, and only then could the international system be accessed. So in that sense, the international system is complementary, and there's a relationship of subsidiarity between these two layers. Let me then turn to the regional system specifically, which is the focus of this series of lectures. How is the regional system specifically adding value to the, for example, the global level of human rights protection? And I think there are three factors that I'll point to. The first is the norms of the regional system that could be more specific and more pertinent to a particular region and the people in that region. Because the UN system brings together so many states from across the world, the kinds of consensus that is reached is relatively minimal. The standards at the UN level often are quite vague and open-ended as a consequence. At the regional level, with a smaller group of more like-minded states perhaps forging standards together, we find greater specificity of norms. So, for example, if you look at the African Women's Protocol, the so-called Maputo Protocol, and you compare it to the UN Convention on the Elimination of All Forms of Discrimination against Women, The Maputo Protocol has much more specificity in speaking to African particularities, such as female genital mutilation and the issue of abortion in Africa specifically. The norms at the regional level are also potentially more in tune, more expressive of the kind of life worlds of people within a region. For example, I suppose in the course of these lectures you'll also hear that the African regional human rights system speaks to communitarian aspects, group rights, the reciprocity of rights and obligations, and also includes the notion of individual duties, which we do not find, for example, in the UN, in the universal system. The second aspect that makes the African or any regional system adding value to international human rights protection is that we find greater accessibility at that level. Now, accessibility could be, in a sense, physical. In Africa, for example, we have an African court. You'll hear more about it in Arusha, in Tanzania. We have the African Commission located in Banjul, in West Africa, in the Gambia. And the seat of the African Committee on the Rights of the Child is designated to be in Maseru, Lesotho. In other words, there is the possibility of actually attending as civil society these meetings, engaging with states, with the members of these committees more easily. But I think the accessibility for me is also psychological, if you like. In other words, the people of Africa just feel that they find greater resonance with these bodies. They feel that these are bodies that are more approachable and easier to actually reach out to. The third element for giving regional human rights protection this kind of added impetus for me lies in the greater possibilities of enforcement and effectiveness. In other words, there is a greater possibility of having human rights more effectively actually implemented at this level. Why is this so? Because at the UN level we have recommendatory bodies. They are not binding in terms of their powers. There are committees, treaty bodies that act in important ways, but there is no world UN Human Rights Court. By contrast, at the regional level, we have courts. We have that in Europe, we have that in Latin America, and we have that in Africa too. And a court, by definition, gives binding judgments. Now, a binding judgment by itself doesn't mean that rights are more effectively protected, but it provides a framework within which effectiveness can be much better harnessed. The fact is, international law, regional human rights law, is not backed up by a police force. The African regional system, which exists under the African Union, the UN system, which exists under that global body, the UN, requires measures to be taken at the domestic level and actors at the domestic level, the national level, to take on the human rights issues. There needs to be naming and shaming, pressure being brought to bear on states who do not abide by and do not conform with the international human rights standards. Ultimately, there could be sanctions, and there could even be like an expulsion from the group of states. But these are infrequent measures that are to be taken. The contention is that at the regional level, with a more cohesive, coherent group of states together, the potential exists that the norms could be more effectively implemented in respect of the states that are the primary violators, but also the primary protectors of these rights. How that plays out in practice is a different matter, and in the course of these lectures we'll look at how and to what extent do these potential benefits of a regional system actually play out in respect of the African human rights system.